Daily list for orders, item 1.
Mayor, please allow.
Mention.
Hello, I am playing for listing one IA for lawsuit orders lawsuit. Hello, in requisition there is an interim order lawsuit.
Next week.
Next week.
Hello, any date lawsuit.
It come up next week, huh?
Daily list for orders, item number 1.
For order.
My lord.
What is that you are seeking?
My lord,
In time review has not been detailed.
my lord,
You will hear, you will have one, records have come over. The original records have come over.
LCR is not.
original records may be.
LCR has not come.
Maybe record, no?
My lord.
Let the LCR be requisition. This thereafter.
Item number 2 for orders.
Here also,
Records are here, Lordship.
reports are here.
Yes, Lordship. And I've gone through the records. Even there is no allegation. And he has, before the LV also, he had submitted voters list of 1970, which is there. And there is no allegation, and it's an ex parte order, Lordship.
Ex parte order.
Yes, Lordship.
But why didn't you go?
Because of financial constraint, in the writ also that plea was been taken, Lordship.
Lordship, Lordship, the order.
The problem is that you didn't go for 5 occasions, huh?
Yes, Lordship.
Or you did not get, you received the notice.
Yes, Lordship. I
Ah.
appeared. And thereafter, I could know because of financial constraint, that plea has been taken in the writ petition, page number, Lordship, 23. I have annexed the writ petition, Lordship.
But what is that thing, what is the basis on which you are claiming that you are a citizen?
I'm citizen because I'm by birth. Even the inquiry report says that I'm born in Bokuni. The LCR reveals that. And I have submitted Annexure B. It states that based on ERO's.
During inquiry, no document in support of his nationality could be produced. The suspect entered India after 26 March.
No,
1970.
documents is cut. Later on, it was cut. Annexure A, it was there. 70 voters list is there.
Huh?
70. Annexure B, 0.7, Lordship. Annexure B,
Oh.
0.7, ERO's report. ERO says that,
If serial number, which year? 1970.
yes, Lordship. And there is no allegation. I'm by birth an Indian.
Then we will remand it.
Lordship, may I please, Lordship.
Ah.
Lordship, we are in review jurisdiction now.
Yes, yes.
And the things that are being placed by my learned friend are about the, if we enter in that jurisdiction, that arena, that will amount to rehearing of the matter, Lordship.
Okay.
And now the Honorable Tribunal had passed the order on 9/8/2011.
Hmm.
And this Honorable Court had passed the order on 11/11/2019. So
Hmm.
there has been a delay of a prolonged period delay, Lordship, and that has already been considered by this Honorable Court by its order dated 11/11/2019 at page 37, Lordship.
Hmm.
And the ground which has been stated by my learned friend was also stated as a ground in the paragraph 6 of the writ petition, Lordship.
Hmm.
And that has already been considered by this Honorable Court. Therefore, there has been no sufficient ground to review this order dated 11/11/2019, Lordship. And at page 38, if we go into the order, Lordship, from the last line, as it transpires from the materials available on record, the
Yeah.
petitioner respondent to the notice heard by the tribunal and appeared on 14/6/2010 and prayed for time to file a written statement on the next 2 dates, also on 21/8/2010 and 30/11/2010. Petitioner prayed for time for filing written statement Hereafter, on as many as 5 occasions, that is so and so, the petitioner remained absent without stay. In such situation, an adverse view was taken by the tribunal and the impugned expiry order opinion dated so and so was rendered. Thereafter, Lordship, having regard to the inordinate delay in approaching the court without any explanation, and for the facts above, we find no sufficient opportunities had been granted to the petitioner to establish his claim as not being a foreigner or to refute the allegation that has been illegally entered into the territory of India after 25/2001. In this context, we may observe that although the procedure of identification for the declaring individual to be a foreign national cannot be regarded to a mechanical exercise, and that fair and reasonable opportunity must be afforded to the proceeding to establish a claim that he or she is a citizen of India. However, such grant of opportunity cannot be enlarged to an endless exercise. A person who is not diligent and or in mindful to take steps to safeguard his interest, he does so at his own risk and peril. Therefore, the grounds stated by in this review application has already been discussed, Lordship, and considered. Therefore, this application is required to be dismissed and it is devoid of merit, Lordship.
And why have you made any explanation in the review petition?
Yes, Lordship.
Why you have come late? Yes.
Financial crisis,
Why is it? Why have you mentioned?
ground 1,
Please.
page 9, Lordship. Necessary documents. Even a notice shouldn't have been issued by the learned tribunal, because record itself, there is no allegation against me. My 70 voters list of my father is there, Lordship, which he had submitted before the year, and as per before the ERO also he had submitted. LBO, when inquiry was done, he had submitted voters list. If we see ERO's report clearly reveals that, Lordship. So there is no allegation. 1516 blank. My place of birth is Buraburi Bokuni, which is in Morigaon district, Lordship. I am not a foreigner. Notice shouldn't have been issued to the proceeding, to the petitioner, Lordship. And that was not.
Yes. This one.
Yes, Lordship, and I have stated due to financial constraint.
Nico. And Ms. Ghosh, Learned Counsel for the petitioner also, review petitioner also Mr. Sharma. Learned Counsel for the state, counsel for the state, as well as Sabka Naam Likho. The present petition, review petition has been filed seeking review of the order dated 8/7/2019. Sorry.
Yes,
Sorry.
11/11,
Page 11/11.
2019, Lord.
Passed by this
Page
court.
37.
Page 13.
38 is the relevant.
11/11/2019 passed by this court in WPC number 4139 of 2019, by which the petition challenging the ex parte order passed by Learned Tribunal was the Learned Tribunal on. What is the Learned Tribunal's opinion?
Learned Tribunal's opinion is at page, Lordship,
34, Lordship.
page
30
34, Lordship.
34.
Yes,
Right,
Lordship.
by which the opinion, ex parte opinion dated 9/8/2011 declaring the petitioner to be a foreigner of post 25/3/19 7 stream was rejected on the ground, primarily on the ground that the petitioner, in spite of giving proper opportunity to appear before the tribunal on several occasions, did not appear, thus forfeiting his right to contest the claim. Full stop. Next para. It has been submitted by Ms. Ghosh that unfortunately, though the petitioner had was served notice and had appeared before a tribunal on several had appeared before a tribunal, but on assigned date by the tribunal, the petitioner could not appear because of financial hardships. Financial hardship in much the petitioner it was difficult on the part of the petitioner the petitioner finding difficult to arrange the financial resources for engaging a counsel as well as collecting the relevant documents. Full stop. Next para. Petition submits otherwise. The petitioner has good grounds to prove that the petitioner otherwise submits that the petitioner has sufficient documents, sufficient valid documents to show that he is an Indian, not a foreigner. Further, it has been also submitted that though the petitioner during the inquiry by the verification officer had furnished the relevant voter list, including the voter list of 1970,
Yes, Lordship.
in showing your name,
Father's name.
showing your father's name, we should have conclusively proved that he was a citizen by virtue of being the son of a person who was casting his vote in 70. Unfortunately, because the proceeding was made ex parte against him, he didn't have the opportunity to do so. Full stop. It has been submitted that under the circumstances, he may be given an opportunity to prove that, to contest a claim that he is an Indian, not a foreigner. Ms. Ghosh also submits that, in fact, the reference ought not to have been made by the referral authority, considering the documents which was made available before the inquiry officer. Full stop. Full stop. Next, on the other hand, Mr. Learned Counsel for the state has vehemently opposed this petition on the ground that the order passed by this court on 11/11 would clearly indicate that that several occasions were several opportunities were afforded to the petitioner to appear. As many as 5 occasions were afforded to the petitioner to appear before a tribunal on 28/1/2011, 15/3/2011, 12/5/2011. 11/7/2011 and 9/8/2011. However, the petitioner remained absent on those dates without taking any steps. And as such, the petitioner had failed to remain alert, and it does not indicate due diligence on the part of the petitioner. And as such, the petitioner has to be blamed himself for the situation he has been placed in. In other words, it is the responsible obligation of the petitioner to discharge his burden cast under Section 9 of the Foreigners Act 1946, which he failed to do so. Under the circumstances, it has been held by this court that no irregularity, no illegality has been committed by the tribunal so as to warrant interference with the order. To stop. We have heard the Learned Counsel for the parties. Judgment reserved.
Thank you, Lord.
There was, maybe your lordship, there was a delay of several
Okay, it
years.
has been also submitted to Learned Counsel for the state. There has been an enormous delay in even filing this review petition. In the message, though the court dismissed the review petition in 2019.
Yes, thereafter approached the Honorable Apex Court and Apex Court in 2021, and the Honorable Supreme Court's order is there.
In response, Ms. Digos has submitted that that it is not that the petitioner was not pursuing his case after dismissal by this court of the dismissal of the aforesaid writ petition. He had approached the Honorable Supreme Court, but he was the petitioner had been asked to approach this court again, and accordingly some delay has occurred, which is not intentional or deliberate.
And lordship, there has been a delay in approaching the High Court in order to petition, lordship, that order of the tribunal was of 2011.
That issue was not decided by the court.
Yes, Lordship.
The writ petition was not dismissed on that ground that it was delayed. The writ petition was dismissed on the ground that even though he was given opportunities, he did not appear.
Yes.
Okay, we'll pass the order, please.
10/3. Item number 3.
Non appears list again and so and so. Yes.
Lord, there are many wrongs.
Many wrong. Tell me 1, 2, 3. 3.
But let me place the ground, my lord.
Oh, one. No. We will not. We are not in a hurry. Just tell us one mistake according to you. One irregularity.
First mistake, my lord. First mistake, I have named my uncle as Nasiruddin in evidence in chief. But in cross, my lord, that was recorded by the tribunal and Nasimuddin. And that has been taken as objection that why Nasiruddin is said as Nasimuddin. That is one of the ground for
No.
rejecting my claim.
Number 2.
Number 2, my lord, I have given connecting certificate, my lord, from the Panchayat secretary, my lord. And he was examined. But his document and the evidence of Panchayat
Mr.
secretary was not
yes,
taken
we'll
into
call-
consideration.
We'll examine. We'll quote notice record intent. Yes.
My lord, in the meantime, my lord, I may be protected. I will surrender before the SP Golpara, my lord. Golpara, no?
Item number 2.
Noor Hussain.
My lord, Noor Hussain, my lord, in this case, my lord, your lordship call for the records because Noor Hussain was once declared as a Indian national. There by a Golpara tribunal, my lord.
The records have not yet come.
My lord. Record is to be received, my lord, because your lordship call for the records of both the cases from Golpara tribunal and Morigaon tribunal.
What was the order passed by this court on 2nd 11/2022?
My lord, record was, order was passed that both the case record may be called for
And
from Golpara.
then
That is the order, my lord. I was not given interim protection, only said that let the record comes. Now, my lord, I may be protected, my lord. Because tribunal declared me as a Indian national. Thereafter, when I shifted to Morigaon, my lord, Morigaon tribunal said that I am foreigner. Order. And my lord, in second case, my lord, I did not receive notice. Expert order.
go one by one. First, second case.
Morigaon case.
Dealing with first case.
That's what expert order.
Which second case? Which second case? Noor Hussain.
Your lordship can see the service report, page 66 to 67.
Morigaon declared you a foreigner.
Yes, my lord, by expert order.
And earlier,
Golpara tribunal declared me that I am not foreigner.
okay, where is it? Where is it? Page
39 page.
page 39. Page 39. Nuruddin. You are Nuruddin, son of
Yes, my lord, Nuruddin.
Santosh Ali.
Yes.
Santosh Ali. Are you Santosh Ali is a real name or what?
My name is Nuruddin.
Huh?
My name is
Here it is in name also.
He sent
different.
us-
Wife? What? What is this?
Nuruddin and Santosh.
Please come to page 39.
Page 39. Yes. my lord.
Please read out the name of the proceeding.
I am coming.
Page 39, Annexure 8.
37, 38, 39. Yes, my lord. Nuruddin, my lord, wife of Santosh Ali. That's another absurd thing, my lord. How Nuruddin can be wife of Santosh Ali?
What do we don't know, nothing.
My lord,
Nowadays, you don't read the latest news.
he is a male
Huh?
person. How he can be
Huh?
wife of somebody?
Nowadays, you have LGBT, same-sex marriage, it's being challenged in. Now it is happening. So wife of
Anyhow,
Santosh
my
Ali.
lord, anyhow,
Yeah.
Nuruddin is wife of Santosh Ali, then also he is Indian.
Page 39.
Son of Santosh.
My lord, I am referring to page 45.
And the ex parte order, page
My lord, ex parte order, my lord, page 59,
59.
59 to 62.
Noor Hussain, son of Sanser Ali.
Sincerely.
Shamsher Ali, Santosh Ali, my lord. That I
What
have
San-
explained.
How can Sanser be Santosh? You can't
But
change
there-
from.
There is some difference of name and it is common everywhere, my lord, in Assam.
Of village Silbhanga.
Yes, my lord.
But Ale Nidanpur. Ale was Nidanpur.
Nidanpur in Golpara, my lord, Nidanpur. And
But then-
Morigaon district, my lord,
But right now we have village Silbhanga.
Silbhanga is in Morigaon, my lord.
So you
Shifted-
came from,
Shifted from Golpara to Morigaon.
why? Why you shifted? Have you explained? No,
My lord,
nothing.
it is day-to-day affairs, my lord. There is a day wage laborers and they search for livelihood, my lord. They used to go from one district to another district,
It was ex parte order.
my lord.
গোৱালপাৰাৰ পৰা মৰিগাঁওলৈকে যদি কথা সেইটো অৰ্ডাৰ বাদ কৰিছে 16 মৰিগাঁও গোৱালপাৰা অৰ্ডাৰটো 2021 গোৱালপাৰাত ইণ্ডিয়ান হৈ গ'লে তাত গৈ মৰিগাঁৱত গৈ পেলাই
Okay, we'll await awaits LCR. In the meantime, also, since this court has passed an elaborate order on 2/11/2022, directing the petitioner to appear before the SP border,
SP border Morigaon, my lord.
have you appeared?
No, my lord, I did not
Why?
direct to appear, my lord. I
Well,
was-
here appear, since the petition have been declared, they shall appear before the superintendent on or before 25/11. You appear,
My lord, I will appear, my lord.
you appear.
Yeah, my lord.
And
I will, my lord.
order of Morigaon Tribunal was
Order
passed
SP
on in
Morigaon.
the year of 2016.
Anyway, we'll see
And
that. We'll call
Order
for the
is-
record. We'll
Order
call-
SP Morigaon, my lord.
20 lot.
In terms, in terms of order dated 2/11/22, the petitioner will appear. Petitioners, how many petitioners?
Petitioners, my lord.
Petitioners,
Yes.
Petitioners
Nuruddin
will-
and his wife and children.
Okay, petitioners will appear before the Superintendent of Police border, Morigaon.
Yes, my lord.
However, and on such and they shall apart from the directions already given, they shall also furnish bail bonds and security of like amount to the satisfaction of the SP border, and they should be allowed to remain on bail.
My lord.
Requisition LCR in respect of both FT, in respect of the FT, in respect of FT case number, the earlier one, case,
My lord. Earlier one, it says 39.
in respect of FT number 3 GLP, bracket 3 GLP /1411 of 2020 passed by the Foreigners Tribunal number 3 at Gwalpara, as well as the proceeding
Another one is 59, my lord.
page 59, as well as the records relating to the proceeding, proceeding in
Foreigners Tribunal
Foreigners
first, Morigaon.
FTC case number 384/2010 passed by the Foreigners Tribunal first, Morigaon. Both the records.
Biometrics also.
Huh?
Biometrics during bail.
Biometrics is there. I think it's already there. Direction is there.
My lord.
Capturing fingerprints, hands, both the hands. Mobile phone also. You got mobile phone? You got mobile phone.
My lord,
Give a mobile phone to the police.
mobile phone.
Mobile phone number, not mobile phone.
Mobile phone number I will
Yes.
give.
You are not asking me to
Yes,
give
sir.
mobile phone to
I will
police.
give.
Mobile phone
I'll
number.
give the phone number.
The phone number. Your phone number.
My phone number.
Yes. Not your personal phone number, the phone
Petitioner's
of
number.
the petitioner.
Yes, ma'am. Only one.
Otherwise, the police will be harassing you.
Only one phone number will do.
Family, yes. Phone number of Mr.
Petitioner number one.
Noor Hussain.
Noor Hussain.
Noor Hussain will also provide a phone number.
Oblige, your lordship.
Supplementary list for motion, item 7.
7.
Lordship,
Bulbul Saikia. What is Bulbul Saikia? Have you deposited that money? That's it. 5 lakh. Have you deposited?
Lordship, before I proceeds, this is against the surface action of the bank.
Correct. Have you received 5 lakh?
No. Lordship,
Have you received 5 lakh?
No.
No.
One thing
Has
more,
the
Lordship,
bank
there is
received
no-
5
there-
lakh?
There is no compromise proposal as such. As on today, there is no compromise.
Anyway, have you received 5 lakhs?
They have.
Which many of the rich people have not paid and they go written off. Have you received 5 lakhs?
No, they have deposited a check. That has not been cleared.
Oh, clear. If you don't want to clear, that is a different
No,
thing.
that
You have
is-
money? Yes, madam.
Lordship,
That check has got money value or just a plain paper?
this is the cash deposit, my lord.
Cash
Check,
deposit.
Check. I have written a Bandhan Bank.
Check. But
I have got
clear or
instruction.
not cleared? If you don't send for clearance, then I don't
We
know.
have sent it for clearance because it takes times. And one thing more, Lordship, they have to submit compromise proposal. The earlier compromise
Mhm.
proposal was rejected.
Yes, we'll see, examine all those things. Yes, have you
Check.
given this 5 lakh rupees?
Yes.
What? Yes.
Lordship, I already have money in my account, my lord. This is a check deposit,
Take the word.
check deposit.
You give a photocopy of your Bandhan Bank, your Bandhan Bank account, Nagi. For what? This check belongs to which bank? Check of which bank?
As per instructions, it is a Bandhan.
Bandhan Bank. You give that,
Check list.
no. The passbook, that you have money. Otherwise it will be useless. You show that you have actual money in your account. You show that you deposit. We'll discuss all this, Mr.
No,
Council.
Lordship,
We'll do everything will take
one
care.
thing- Just one thing your Lordship may observe, because by this, their amount due is more than 1.5 crores.
We'll see that. We'll
No,
file and
No,
we-
they have submitted for proposal, they have not submitted any proposal for.
that is what we'll see that because.
Let them submit proposal for compromise. That thing your Lordship may observe.
But you said that there was a one-time proposal.
No,
Madam.
that is the crux of the
Lordship,
matter.
this is
They are
one-time
one-time
proposal.
settlement, I am submitting to your Lordship that they have failed to submit the offer, and that the one-time settlement has been rejected, that has been informed to them.
Correct, because they could not pay, no? That is what.
Then the matter which has been rejected, we cannot proceed with that one-time
Correct,
settlement.
because-
They have to submit afresh.
Correct.
And one thing, Lordship, that one-time settlement was pertaining to one account. Now 3 accounts has gone to NPA.
3 account.
Yes. 3 accounts has gone to NPA, and
Bulbul Saikia, you are in deep trouble.
Lordship, I am submitting
How much money you have taken from State Bank of India?
now as on today, 1 crore 76 lakhs
1
79.
crore. You have to perhaps sell off your, luxurious home you have built in Guwahati. And pay that. You have property in Guwahati.
I'm
Like how
getting
many
the-
flats, houses you have? You don't have. Housing loan, all housing loan. You have built a house.
Lordship, kindly come to the page number 21. My petition.
Lordship, this is the letter by which we have rejected the OTS.
This is certificate amount, not on that, my.
We have rejected the OTS.
1 crore
This is the
something,
OTS
that is the
proposal, and
certificate amount.
that has been,
Passed by the DRT, my lord. Lordship, kindly come to the page number 21, 31/01/2022. Point number 2, OTS amount is 42 lakhs 12,091.
Mr. Bulbul Saikia, you have to place all the facts properly before this court.
Lordship.
If the bank is able to show that you have not put the facts properly, then On that ground only we'll throw out your petition. You must come with clean hands. That's what
Lordship.
low demands. We'll see what difficulty you have. We'll see what is the law also. We'll hear the bank also. But first of all, you must come with clean hands and disclose all the facts, your liability, and also show that you have already, you have this 5 lakhs in, and not only 5 lakhs, you have to have more lakhs, because otherwise we can't allow you to go away only with 5 lakhs. Otherwise bank will suffer,
Lordship.
isn't it?
Lordship.
You, today is what day? Today is, we'll hear you, bank. We'll
No,
protect your
Lordship,
bank interest also,
the-
correct?
the Lordship may kindly consider my submission and in record that the compromise proposal has been rejected, and this amount which they deposited will be in the no lien account.
No,
It will
he
not
also
be-
said that petitioner defaulted to make payment in terms of one-time settlement agreed of the party. Obviously, if the petitioner does not pay, you will resign, you will
Yeah, and that
reject
has been
it,
communicated to them.
correct?
That has been
When it was communicated.
On 5/7/2022,
Uh,
I have given the letter.
Now, one thing we'll do is that, see, how much actual, what is the amount which he actually owes? You say this is 5 lakh. Or whatever, 5 crore, whatever it is.
Yes.
How much you know how much you owe to the bank?
Lordship, as per
Lordship,
the
that-
OTS, January, my lord, 44 lakh something, 42 lakh something.
See, do one thing. Don't tell us. We are not arbitrators sitting there.
This 44 lakhs is some,
This
is
is not-
pertaining to only one account,
Correct. What do you
only
do?
one account.
Yes. What we do
There's
is that,
three-
see, the bank, if you get money, you should be happy also.
No,
Ah.
Lordship, this is a matter regarding to SARFAESI. Previously,
correct.
they have gone to the.
We are
DRT
aware of the limitations of the
under-
court.
Under section 17,
We'll refer to Lok Adalat then.
and both were rejected.
The Lok Adalat, then Lok Adalat can pass order also. But instead of waiting for Lok Adalat, we'll see if he is willing to give that money. If you are satisfied, then accept it. After all,
Yeah, let him submit compromise proposal fresh.
exactly. That is what we are going to say. Huh?
Yes. let
You
him submit.
immediately submit this is the amount I owe. Can I pay this amount in this manner? You give it to the bank. If the bank agrees, fine.
Yes, it is,
Otherwise, bank may say no. You have to increase the amount.
right,
Correct. You are the one who has to do this, not the bank.
because it is a discretion of the
When
bank.
can you? Yes, correct, absolutely. When can you submit the one-time proposal? Tell us. Then we'll fix on that day.
Yes.
But by that time, you have to bring that proof that you have this 5 lakh. Not only 5 lakh, you have much more than that. Don't hide your money in some other bank.
Within 10 days.
Otherwise, you'll have problem. All your property will be confiscated. All the houses you have built, all the big mansions you have built, will all confiscated. Will be all attached by the bank. And you will be roaming around the street
Within 10 days, yes. So
within 10 days.
Yes.
one
let him-
thing, may I submit, my lord?
Yes.
Lordship, page number 26, I have submitted the application before the bank, my lord, praying that my earlier OTS, January OTS, as per OTS, I requested to
Very
take the
well.
money.
See, madam, correct. But the bank says that has been rejected, so we don't want to do that.
There is
You
no
make a
rejection.
fresh.
This letter was.
Oh, why
submitted on
again going to that?
17th
Doesn't
April.
matter. See,
That is-
bank is, this is Lanet Council for the bank is fairly offering you. Give a proposal, a fresh proposal
Fresh
and if
proposal of the
yes.
entire,
ah, of the
of the
entire
three-
amount,
of the 3 loan accounts.
3 loan accounts,
He is submitting,
only one. You are forgetting other 2. Just come up with a fresh proposal.
of the
You want
3
10
loan accounts.
days? We'll give you 10 days. Give and consult all your other.
3 loan accounts.
Okay. And Miss
Pibora.
Pigora, Lanet Council. Also, Mr.
KK Nandi,
KK Nundi, Lanet Council for the bank.
Lordship.
It has been submitted that the petitioner has though petitioner has deposited 5 lakh, it is by way of check. And by way of check, and it is desirable that he proves that the petitioner has sufficient fund in the account. Otherwise, it will be a futile exercise. Be it as it may, it has been submitted that the petitioner owes as much as 1,7676,79,494.00 on 3 accounts, which the petitioner is having with the bank. And earlier OTS, which was offered to him, has been already rejected on account of his default. Under the circumstances, the bank would require the petitioner to make a fresh proposal for one-time settlement. And if it is found the same acceptable to the bank will proceed accordingly. Accordingly, the petitioner shall submit a fresh proposal for discharging the debts, for
Of
which
3 accounts.
on three accounts or the 3 accounts, and the same may be submitted before this court, before the bank. Before the bank, you submit before the bank within a period of
10 days.
10 days. 10 days মানে আজ কি তারিখ?
6 December.
হ্যাঁ
6 of December.
Today is 6 December. 10 days হলে when is the 10 day expiring?
16.
Huh?
16 Lord.
16.
December.
Then the matter will listed on 19th of December. Don't fail.
Maybe on 20th, Lordship.
20.
19th, I have 20.
No problem. This is a matter on 20.
19th, Lordship.
Till then, my lord, my possession may not be.
Huh?
Till then, my possession may not be.
Till
No,
20.
Lordship,
No
Lordship,
problem. Otherwise, if he is evicted from my, he
no,
will pay.
Lordship may dispose of the matter
On
this way that they will submit the proposal and we will consider accordingly.
yes,
Bank
we
will
can
consider.
close also if you
Yes,
want.
Your Lord, until then, no,
Yes, madam. Yeah, until then we'll direct not to take. Is
Yes.
it okay? It is good for you. We do it.
this.
You have such an offer from the other your opponent. You'll never get this kind of offer so frequently in this
Because
court.
Lordship may
Think it over. Yes, you submit. No, why you are looking at us? You are not.
no, your Lordship may dispose of the
Very good
matter.
proposal from the bank. How
Yes.
you will not get any better proposal.
Otherwise,
Yes, yes.
he will submit the proposal within 10 days and within 10 days thereafter we will
Communicate the and
within 2 weeks thereafter, we will communicate our decision.
decision. And if it is acceptable, fine. If it is not acceptable,
Yes,
you know,
we-
you are a
we
lawyer.
will
You
agree
know
on-
what to do. You are a lawyer. You know what to do. We don't give free legal aid counsel here, no? We don't give free legal aid advice. Sitting here is a judge.
To
You
that,
are a
your
lawyer. You
Lordship
know what to do.
Observe and dispose of the matter.
Okay, likho. Had me so and so had sab kato. All confusion, huh? So and so. It has been that the present petition is filed seeking a direction to respondent authority, respondent bank, to set aside the order dated 21/10/2022 passed by the district magistrate Dibrugarh, and the vacation notice dated 29/10/22 passed by the authorized officer, and also directing the respondent bank and to allow the petitioner to liquidate his dues by granting time till March 2023 as per the OTS one-time settlement proposal dated 31/1/2022, and till then not to take any coercive action, including eviction of the petitioner from his residential premise in a mortgage property, that is a plot of land measuring 0B1 Katha 10 Lessa covered by dark number 597/O/801, page 15, and of Patta number so and so situated Boraga Dhoi Gaon under Tipling Mauza of Tengakhat Revenue Circle District, Dibrugarh. Full stop. When this matter was taken up on 2/12/2022, this court had directed the petitioner to submit a ₹5 lakhs to the bank on 5/12/2022 with a proof thereof to be presented before this court. Today, when the matter was taken up, Mr. K. Nundi, learned counsel for the bank, has submitted that the said one-time settlement which the petition is referring to has been already rejected by the bank on account of his failure to comply with the terms and conditions of the OTS. Full stop. Thereupon, the petitioner owes as much as 1,76,79,494 on 3 accounts, that is credit card, cash credit under account number so and so, and the 2 housing loans the petitioner took under account number so and so. Full stop. However, the petitioner has defaulted in repaying the said amount, and resulting in taking the aforesaid action by the bank under the SARFAESI Act. First off. However, Mr. Nonri has very fairly made a proposal before this court that if the petitioner is still willing to liquidate the amount in amount on the two noun, he may the bank he may furnish a fresh proposal to be submitted to the bank within a period of 10 days, which will be considered a bank. And if the bank finds it acceptable, the necessary actions will be taken for liquidation of the amount as per the terms which the bank which will be acceptable to the bank. Full stop. And full stop. Under the circumstance, we of the view that instead of keeping this petition pending before this court, the petitioner, as proposed by the counsel for the bank, will submit a fresh OTS, one-time settlement, to the bank within a period of 10 days.
Of 3 accounts.
In respect to the aforesaid 3 accounts, and thereafter, the bank will intimate to the petitioner as to the acceptability of such one-time settlement. And if it is found, if it is accepted by the bank, obviously the petitioner will do the needful to act according to the term OTS. Full stop. OTS. Full stop. Accordingly, we have the view that present petition can close. However, till such communication is received from the bank on the OTS that may be submitted by the petitioner, as mentioned above, no coercive action shall be taken against the petitioner.
Obliged.
You okay?
Mm.
Petitioner stands closed.
Obliged.
Daily list for admission item 3.
My lord, here in this case, my lord, LCR has received, my lord.
It is bank 805. Yes?
LCR has come, my lord.
So
My
we'll
lord,
take-
thanks for hearing, my lord.
okay, since the LCR has, since the records have been received, the matter will be listed for hearing. Yes. Item number, yes.
Item number 4 for hearing.
What is this hearing? NIA.
My lord, interim may continue, my lord. Interim order continued.
Other interim order will continue. What is this? Bail. What is this? Criminal appeal? Appeal. Hearing.
They have come against the grant of bail.
They have come against the granting of bail.
Bail to me.
No, it is a granting of bail.
You will hear
Your lordship,
today because he only yes, yes.
Lord, before your lordship make a call on this matter, there was a kindly peruse the last order.
Now this place that
The
what?
order was that there is a repetition is pending
Oh,
in Kohima Bank.
One thing, your lordship will kindly note, Mala. I do not know. His name is not reflecting that.
No, we have filed our wakalatnama. It has been there. Yesterday we have filed.
I do not know whether the Wakalarama has come before your
So
lordship or
technical,
not.
sir. So don't go by so technicality, sir. We have already filed it.
Because
File question or something?
it is a simple matter, Mala. Your lordship will.
file kurde.
Filed yesterday, you have filed it.
File.
And even your lordship, if it goes on married also, this appeal is not maintainable because they have come against an order where they are praying that 43 D5 will be attracted against me. But the bail has been granted in 10 and 13 of the UAP Act, where 43 D5 does not come into play. Anyway, my lord, there is a writ petition is pending. Their matter is fixed on 8th of this month again.
Oh, is it so?
Yes, my lord, where we have challenged the virus of certain provisions and the matters would have been disposed of, but due to paucity of time could not be taken up. So matter has been fixed on 8th, day after tomorrow at Kohima bench.
Then let it come after that. We'll see. Mr. Das.
Let it come on 12 or 13.
My lord, let us not be given such a short date, my lord. Let it, the moment that matter that finishes, it can be taken up, my lord. We will inform.
So when we'll know that it will be finished?
My lord, because
Only after 8.
my lord,
That we'll know only after 8.
my lord, only after.
Maybe 10 also.
My lord.
Maybe 12 also.
Let it come on 12 or 13, Mala. Let it- 12 or 13, whatever your lordship. Next week.
Yes, Tariq, yes, that's so.
16 will be better, my lord.
Huh?
After 16, it will be better. After 6,
After 16 will be better.
after 16 will be better.
Now, which one is better? Tell us.
After 16, any date, my lord.
Oh, again, you say after 16. Don't say like that. After 16.
After 16, let it be on 19, my lord.
19.
No, let it be on 19.
19 December.
19 December.
But no, don't fix on a non-hearing day. If it is going to be hearing,
20, my-
20,
20.
20.
20. Okay. It has been submitted to the bar that the connected, that a related writ petition being WPC number 4,
K.
between bracket K, oblique 2018, has been already fixed before the appropriate bench in Kohima
Kohima on 8th, my lord.
on 8th of
This 8th of December.
this one. Accordingly, parties submit that the matter be listed thereafter. This accordingly on 19th as
20.
agreed by the party. 28th, huh? Yes.
Oblige you.
For hearing, item number 5.
Let my name
Sorry.
my name be reflected.
Okay, showing. But your name is already there.
No, it will be reflected, my lord.
His name.
My lord.
His name is, I do not know whether my name.
But your name is there. DK. No, sorry. Oh, in the order. Okay. And Mr. Lanet Senior Council with us, assisted by Ms.
PK Darji.
PK
Darji.
Darji.
My lord, my name may be reflected. We have already filed a Wakalatnama.
But here there is a strong
only-
objection. Whether you even
Whether the Wakalama come or not.
name of the council for the
Normally,
name of the council for the respondent be reflected in the cause list.
Subject to,
Whosoever it is.
subject to seeing the Wakalama.
my lord, normally in memo of appearance also we can appear in criminal matters. Oblige the lordship.
Item number 5.
Yes. Item number?
I don't know, 5, your lordship.
Key, what is this? Rubaya Khatun.
Rabia Khatun, your lordship, judgment
This
is
is
that,
for hearing what? What is to be heard? Tell us.
what happens is that, your lordship, I have submitted as many as 14 exhibited documents, your lordship. I have
Hmm.
relied upon 14 exhibited documents.
Then what happened?
But the thing is that, your lordship, that learned tribunal disbelieved the documents, stating that the opposite party failed to establish the link with the parents, your lordship. That is what the judgment agency.
We will hear. We will hear. Today is not a hearing date. We will list on the hearing date. We'll on the hearing date. We'll fix it on the hearing date.
Lordship.
Huh?
Lordship,
You are on interim also, no?
interim, your lordship.
Okay. Yes. Don't fix on. Oh, today is a hearing day, no Tuesday. Sorry. Oh, I was Monday. Criminal matter. Yes. There's some dead reference, I think. Dead reference, no?
Yes,
No?
1 to 4. That reference.
That reference is there. Okay, then. Yes, next.
Item number 6.
Oblige.
Majeda.
Statement.
Majeda, yes, what is this Majeda? 5 minutes matter or
Yeah,
half
please,
an hour
Lordship.
matter?
My lord, brother, my lord, deposed my lord Gavura deposed my lord. I have submitted my lord 1966 voter list, my lord 70, my lord, and subsequent other voter list, my lord.
And what
Even
did
though,
the
my lord, I
learned
have
tribunal
to
say about your brother?
declare. My brother, my lord, deposed my lord.
But what did the learned tribunal say about your brother's?
My lord,
deposition?
some distinction, he stated that some distinction between their statement, my lord. So, my lord, can I, my lord,
Tell us, just don't open your, just tell us, what is that, what is the discrepancy? Tell us.
my lord, kindly, my lord, turn to page, my lord.
No, tell us, what is the discrepancy?
Because my lord, in their my lord, deposition, my lord, my brother, my lord, learned tribunal, my lord, said that my lord, my brother, my lord, said that when my lord, I have shifted my lord, and my lord in some my lord discrepancy, kindly my lord.
You
turn to
tell
page.
us, no,
Yes, my lord.
you
And
tell us.
some other my lord, discrepancy is that
Oh,
my
you
lord.
tell us, no, why
Yes,
you,
my lord, that my lord, I have submitted all the voter list, my lord. Why, my lord, I have not stated, my lord, the
you
relation
said
of my
that
lord.
tribunal found some discrepancy. What
Yes,
is the
my lord.
discrepancy? Tell us.
First discrepancy is that, my lord, I have submitted all the voter list, my lord, from 1966, my lord. But my lord, learned tribunal said that, my lord, my lord, instead, my lord, I have my lord, established linkage with my father, mother, my lord. But my lord, other my lord relatives, my lord, I have not stated their relationship. That is my lord, uncle, my lord. That is their man. That is why, my lord, I have been, my lord, declared, my lord. So, my lord, Gaubura said, my lord, my own brother, my lord, and from 1966, my lord, subsequent, all other voter list I have submitted, my lord.
Okay, we'll hear. We'll hear. Not because we'll hear some other day. Okay.
My lord.
Please again on sense.
My lord, kindly 20, my lord. Thank you, my lord.
After vacation.
Hearing list, item number 1 to 4.
Interim order, my lord. Kindly
Ali
20.
interim order will continue.
Obliged.
Item number
1 to 4, hearing list.
the bank. Moinul Haq.
Moinul.
Umbrella.
Umbrella.
They have finished their submission. That
Yes,
is-
they have finished, my lord. So for, on the last occasion, my lord, with regard to Moinul, what are the materials against him, my lord?
Yes.
Material against him is this, my lord. That a unfortunate lady lost her life. The circumstances against Moinul, my lord. One is that, my lord, that a lady had lost her life. Her belonging has been recovered, my lord, that's been proved. And my lord, subsequently, arrest of Salim, a statement has been given, my lord, leaving apart his statement before
You are mentioning about Moinul's role.
Moinul, yes. What
So-
are the circumstances?
Huh.
One
Number
is
one?
that death has occurred, my lord.
Mhm.
Next is with regard to recovery of the materials of the deceased. Thereafter, my lord, a statement been made by Salim, the accused, excluding the inculpatory part, my lord. Some informations were received with regard to commission of the offense by Moinul. So much of informations, my lord, which amounts to confession, my lord, which is specific bar under 25 and 26, my lord, excluding that. Whether the question before this honorable court would be that any other information which is not within the knowledge of the investigating officer been brought to the knowledge of the investigating officer with regard to involvement of any other person would amount to this part of this particular statement would be admissible in evidence. My understanding of regard to, my lord, the Evidence Act, my lord, so far with regard to inculpatory part, so far involvement of Salim is concerned, any inculpatory part statement that has been made so far Salim during police custody is inadmissible. But any other information that has been gathered during investigation with the involvement of any other persons in the commission of the offense would be an admissible evidence. And that Moinul was arrested, my lord. He was taken into custody. And thereafter, Moinul leads the investigating authority to the place wherein one of the crime weapon, that is the umbrella, has been recovered. The other side made an argument, my lord, with regard to recovery, with regard to PW1 and PW7, my lord. But the PW6, but the other who have recovered it, the confusion they intend to create that in one case the police has taken out and another case the Moinul has taken out. But while cross-examining the witness itself, my lord, that confusion has been taken out of the record because the witness himself during cross-examination admitted that it is Moinul who has taken out this umbrella and recovered. Now the next question arises against Moinul, which is a very strong evidence against him. Then how come he know about that umbrella? It links to the offense itself. So his presence at the place of occurrence and this, my lord, recovery of the umbrella, and that there are witnesses to this leading to discovery, wherein they have been given the opportunity to cross-examine at length, could not even shake it, my lord. The evidence remains intact. So there is nothing on evidence on record to disbelieve the recovery witness and with regard to leading to discovery. My lord. And so, my lord, to that aspect, my lord, I'll cite some of the cases on the basis of which only leading to discovery amounts to, my lord, convictions, my lord. Now, two judgment has been cited by the other side so far Moinul is concerned. One is 2022 SCC Online, Supreme Court 1449. Now, here in this case, it's ended in acquittal.
Which one they relied?
2022, my lord, SCC Online 1449. That is, my lord, Muni Krishna, Elias Krishna, etc. versus State of Ulsur PS, respondent.
Which one? Is it they have relied?
Muni Krishna, Elias Krishna, etc. my lord, versus State of Ulsur PS.
Muni Krishna.
Mm-hmm.
2022 SCC Online SC 1449.
2022
SCC Online SC 1449.
Muni Krishna.
Muni Krishna. They have submitted the judgment copy to this honorable court. This one, eh? Did I wrote a copy?
So relied upon by whom?
Counsel for Moinul Mai. Okay.
That is 2022 SC Online SC
SCC Online.
SCC Online SC 1449. Muni Krishna, Elias Krishna.
Regarding?
Leading to
Circumstantial
discovery,
evidence.
my lord.
Circumstantial evidence. Leading to discovery, my lord, I am relying on other Guwahati High Court judgment.
I'll come to that. It is.
Will
I said-
given to us this
Yes, it's been
Yes, we have provided
Furnished.
this,
earlier.
Yes.
earlier one.
now here in
No, you
this
just take,
case.
no, don't print out if it is provided unnecessary.
Get a copy of that.
You have already provided, no? The printout copy.
Print out copy. I have one.
Just a minute, maybe it's there.
Yes.
I said. I said. This is being submitted by the council for the appellant minor Moinul. Now, here in this case, one of circumstances was leading to discovery, and he was acquitted in this case. The ground of acquittal is, my lord, that's been reflected in paragraph, my lord, 25. Kindly read 25, my lord. The ground of acquittal. May I read it, my lord?
Para 25.
25, yes. Why this disclosure statement has been disbelieved, my lord? May I read it, my lord?
Yes.
As far as recovery of gold ingot is concerned, PW1, the son-in-law and the complainant has said in his evidence before the court that he does not recognize the ingot and it does not belong to his father-in-law. Therefore, the gold which has been recovered has not been identified as the one which was stolen from the house of the deceased. The recovery of knife is also doubtful. Firstly, Venkatesh, who had led the discovery, had mentioned about the knife and its disposal on 1/2/2001 when he was arrested. The recovery, however, was made on 15/5/2004 and a half months later. Why such a belated recovery was made has not been explained. Secondly, my lord, the independent witness to the recovery, PW10, Murugan, also has turned hostile during cross-examination as he said that he does not recognize Venkatesh accused on whose pointing out the alleged recovery was made. So much for the recovery of the murder weapon, my lord. And because of these reasons, my lord, he was acquitted, leading to discovery. But here, there is causal evidence. There is nothing to disbelieve the recovery witnesses and the recovery exhibit, my lord. There is nothing, absolutely nothing on record. So only on that basis, my lord, because this recovery witnesses didn't support the prosecution case, acquittal happened. Now, another judgment has been submitted by the Learned Counsel for Moinul, my lord. Our High Court judgment, criminal appeal number 50 of 2019, Orup Rabha versus State of Assam. Now, here is also a case wherein, my lord, leading to discovery was one of the circumstances, my lord, and the only circumstances. And why he got acquittal in this case, my lord, that has been reflected in paragraph 29 of the judgment. May I read paragraph 29, my lord?
Para
29, my lord. Why acquittal, judgment of acquittal was passed, my lord? That is because, my lord, may I read it? If the accused, while in police custody, had given information leading to the discovery of the dead body, the said fact would undoubtedly be regarded as evidence within the meaning of Section 27 of the Evidence Act. However, from a careful examination of the materials available on record, we have failed to decipher as to what was the information, if any, given by the accused so-and-so, or fact disclosed by him to the police, based on which the dead body was recovered. Rather, as noticed above, we find that there are material contradictions and omissions in the testimony of the witnesses pertaining to the presence of the accused so-and-so in the place where from the dead body was dug up. So on this very basis, my lord, leading to discovery was, my lord, not been believed, and as such, it ended in acquittal.
Read paragraph 32 also.
32 also, my lord. Yeah. In the present case, even assuming the dead body was recovered on the basis of facts disclosed by the appellant while in police custody, even then, that alone would be sufficient to convict the appellant, my lord.
Insufficient.
Insufficient to convict the appellant for committing the murder of the victim. The prosecution in this case has not only failed to establish all other links in the chain of circumstances pointing towards the guilt of the accused, but has also failed to even remotely connect the appellant with the kidnapping or murder of the victim. We are therefore of the view that the prosecution has failed. Now, my lord, here this paragraph with regard to this, and the facts and factual metrics of our case, my lord, are totally different. Leading to discovery with regard to a weapon which has been hidden under the bush, and within the personal knowledge of this particular accused appellant, my lord, who have led the police to that place and recovered them. So his presence at the place of occurrence is being, so far exploratory part is concerned, of Salim is concerned, are information gathered from Salim, my lord, which doesn't amount to confession, admitting his own guilt. But that information with regard to which was not within the information and the knowledge of the investigating officer is a admissible evidence. On that very basis, his presence at the place of occurrence comes into the picture. Thirdly, my lord, the plea of alibi that has been taken, my lord, by Moinul is concerned, my lord, it is false on the face of the record. So in that view of the matter, that when a knowledge about a particular fact is within that particular person, and he has not come out with clean hands, and thereafter he takes a plea of alibi, whereas he dispute the my lord recovery also. All false pretext has been taken, my lord. And so far with regard to his presence at the place of occurrence and taking alcohol or otherwise, my lord, intoxicated thing has been proved. In that view of the matter, my lord, that chain with regard to that his presence at the place of occurrence and no other persons, because this has been an area wherein it's been a little bit isolated, my lord. It's not within the vicinity of a, my lord, wherein people reside or a market area or as such, my lord. It's been this one, my lord. And there are no reasons why, my lord, this particular information, the investigating officer during custody of Salim had divulged with regard to involvement of any other accused persons, my lord. This is an information, my lord, wherein, my lord, the involvement of an accomplice has been there. In that view of the matter, my lord, Salim could have stated any other name, my lord, or otherwise his involvement also only, my lord. But why he has named it, my lord? Because of the fact that this has never been, my lord, in the picture. Only because of Salim's arrest, my lord, on interrogation, this information for the first time has been elicited during, my lord, interrogations. And these are the informations, my lord, which are admissible evidence, my lord. And that amounts to leading to discovery of a particular thing, my lord, which has already been discovered, my lord. This is my respectful submission with regard to Moinul, my lord. And so far as other judgment is concerned, my lord, my learned senior colleague, Jiaul Kama, my lord, he has submitted, my lord. Ravi Sharma, 2022 8th SCC, my lord, 536. This was an appeal against acquittal, my lord. Now, here, why the Supreme Court has, my lord, refused to, my lord, the reasons are at paragraph 18 of this particular judgment.
Which judgment?
2022, my lord, 8 SCC 536. My lord, 22, 8 SCC 536, my lord. Trial court acquitted, High Court convicted, my lord, Supreme Court reversed it. And why the reversion grounds is this, my lord, at paragraph 18.
Yes.
I'm reading paragraph 18, my lord, of this judgment. Similarly, the trial court rightly doubted the recovery under section 27 of the Act. There was no need to take PW2 and thereafter make him to sign. There are a lot of contradiction in the evidence of rendered. PW2 has stated that many persons were available at the time of recovery. No statement has been obtained from any of them. PW11, the head constable says that the investigating officer PW14 did not ask any neighbor to join the investigation. PW8, who is the sub-inspector of police, has deposed that none was forthcoming. A similar statement was also made by the investigating officer. There is discrepancy on the mode of traveling to the place from where the recovery under section 27 of the Act was made, along with witnesses, namely 2, 8, 11, and 14. While PW2 has stated that the police team used a jeep and motorbike, the witness has stated that it was either motorbike or by foot, while one witness says that it was a gypsy. We do find contradiction with respect to the place of arrest, followed by the disclosure statement, my lord. On this very basis, my lord, trial court acquitted, High Court reversed it, my lord, and the Supreme Court upheld the trial court judgment, my lord. Next judgment that's been submitted, my lord, by senior colleague of mine, is, my lord, our High Court judgment, Gobind Singhal, my lord, wherein, my lord, with regard to 313 statement is concerned. Now, in this judgment, my lord, that is Criminal Appeal 350 of 2019, date sentence reference 3 of 2019, and Criminal Appeal 396 of 2019. To remit to Chandra, no? Send back. In this case, my lord, yeah. So it was sent back for recording 313 again, my lord. Now, in this judgment, Sajid Khan's case has been referred to, my lord. In Sajid Khan's case, what happens, my lord? There were witnesses wherein they turned hostile. Sajid Khan case, my lord, that is been decided on 1/12/2021, media copy. Criminal Appeal number 391 of 2018. In that case, I was for the appellant, my lord. What happened when some of the witnesses turned hostile? Now, prosecution, after taking the consent, and even it is not on record, that it's a matter of course a person has been declared hostile, and thereafter whatever is 161, that has been recorded. And thereafter one line cross-examination, that's all. Now, during 313, never these questions were put by the trial court and convicted the accused. So on that very pretext, my lord, appeal was allowed, and the case was again in Sajid Khan case also, it was remanded back for recording 330. But here is a case wherein, my lord, every incrementing materials has been put. Yes, learned senior colleague has rightly pointed out that the IO's evidence is in pages with regard to this. But every statement with regard to every evidence that has to be put, the requirement of 313 is this, that every incrementing material, an opportunity is to be given, my lord, to the accused person to explain it. Now, it is not a case wherein no opportunity has been given. Here in this case, every incrementing circumstances that has appeared from evidence on record is being put to the witness, my lord. And he gave an explanation to this. Even IO's evidence, my lord, all has been read over, my lord, as for records. And he have given an opportunity with regard to this. And even one of the accused stated after this, my lord, that he wants to adduce defense witness also. And for that purpose, D1, DW2 has been examined by Salim to prove the plea of alibi. But that has been demolished by way of cross-examination. So far, 313 is concerned, my lord. These are the two judgments with regard to this, my lord. Next judgment, my lord, referred by learned senior colleague, my lord, Jiaulda, 2022 8 SCC 440, my lord. This is regard to Evidence Act, my lord. Now, my lord, here in the judgment, my lord, last portion, my lord, I'm reading the last paragraph. Upon the discussion made as aforesaid, we are inclined to dismiss the appeals filed being criminal appeal number so-and-so, 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 conferring the conviction rendered by the High Court. The conviction rendered by the High Court against the appellant in criminal appeal number so-and-so, arraigned as accused number 10 and 13 stands set aside. Consequently, the appeal filed by the accused 10 to 13 being criminal appeal number so-and-so are allowed by setting aside the judgment rendered by the High Court and restoring the acquittal rendered by the trial court. Now, my lord, partly it was allowed, partly it was disallowed. The main paragraph with regard to this is paragraph 15 and 51 and 52. My lord, why some of them were convicted by the trial court, High Court upheld the conviction, the matter went to the Supreme Court. Why Supreme Court has upheld this, my lord? And why some of the accused persons who are who was acquitted by the trial court, reversed by the High Court, and again the Supreme Court reversed the order of the High Court. Why? Because in paragraph 51 and 52 is very important, my lord. I'm reading it. The High Court places reliance also on the recovery coupled with scientific evidence. We believe that such recovery are expected to be proved if relied upon by the court. As against PW 35, who signed the recovery Mahajar He was not even acquainted with the place and lived in far distance area. Similarly, PW 33 is not a resident of the locality. Except for PW 4,